do you believe that the Supreme Court's decision on executive immunity constitutes an exoneration of President Trump's conduct in the months and weeks leading up to January 6th and on January 6th?
No.
Would you just explain that for us, why you don't see that as an exoneration for what he did?
Sure. I understand the Supreme Court decision. And if I just go back for a second, this was an issue we litigated in the district court. The district court agreed with us. We litigated it in the Court of Appeals. The Court of Appeals agreed with us. We litigated it in the Supreme Court. The Supreme Court majority did not agree with us. They took a view of executive power that was more expansive than what we argued. I disagreed with it for the reasons we set forth in our brief and the reasons stated by the dissent in the case, Justice Sotomayor. But it is the law of the land. And what my office sought to do in responding to that was to follow the law and see, do we still have a case? And I think the evidence that we had after that decision remained powerful. I talked earlier today about state officials who put allegiance to the country before party. Those officials from Arizona, Wisconsin, Michigan, Pennsylvania, all those witnesses, right? All those witnesses would still be available to us. The heart of our case would still be available to us. And I think it's important to know that, well, you know, our view was that he abused his authority in the Justice Department to effect as one way to effectuate this scheme. This was about him as a candidate trying to say he won an election he didn't win. And so having to frame this in that manner, obviously it limited some of the evidence. That's why we had to supersede the indictment. But I don't think it was an exoneration because I still believed that there was substantial evidence that would allow us to prove the case beyond reasonable doubt.